Our first case occurred at Fulton County Courthouse in Atlanta, Georgia. Jeffrey Lamar Williams, rapper known as Young Thug, was accused of being a leader of a criminal street gang well known as Young Slime Life. The prosecution brought charges including participation in criminal street gang activity and conspiracy to violate Georgia's Racketeer-Influenced and Corrupt Organizations Act, among other drug and gun charges, in a sweeping indictment on May 9, 2022. The core of the prosecution's case relied on Georgia's broad RICO statute, specifically OCGA Section 1614-4, which makes it unlawful for any person associated with an enterprise to conduct or participate in it through a pattern of racketeering activity. The state alleged YSL was an illicit criminal enterprise and sought to use more than 180 overt acts, including social media posts and rap lyrics, as evidence of this pattern, a controversial tactic that sparked national debate on First Amendment rights and proposed legislation to protect artistic expression. The trial initially was being presided over by Judge Ural Glanville, a Superior Court judge for Fulton County. According to sources, Judge Glanville met in his chambers with Prosecutor Adrienne Love, a witness, Kenneth Copeland, and the witness's attorney. Mr. Williams' defense attorney, Brian Steele, was not informed or present for the meeting. This private interaction qualified as an ex parte communication, a prohibited communication with a judge by one side of a pending matter without the other side's knowledge or presence. Under the Georgia Code of Judicial Conduct, Rule 2.9, judges are generally forbidden from initiating or considering ex parte communications concerning a pending case, with narrow exceptions for administrative or emergency purposes that do not deal with substantive matters. The failure to notify the defense raised serious concerns about the defendant's constitutional right to a fair and impartial tribunal and the appearance of impropriety, which is a key standard for judicial ethics. On July 15, 2024, Judge Glanville was removed from the case following successful recusal motions submitted by the criminal defendants' counsel. Judge Paige Whitaker assumed the trial going forward. In a later development around September 30, 2024, the defense asked for a motion for a mistrial. The defense claimed an item the state brought as evidence contained hearsay, which is an out-of-court statement offered in court to prove the truth of the matter asserted, and is generally inadmissible under the Georgia Evidence Code unless a specific exception applies.
Your Honor, so well, first of all, my motion is a motion for a mistrial. Based on the actions of the prosecutor. My objection initially to the item was that it contained hearsay. The state represented at the bench that it was not hearsay. There was no hearsay contained in it. We did not address the issue of what the state already knew, which is that there was a phone number attached to it that she was going to try to elicit testimony from this witness about who that phone number belonged to. That in and of itself is speculation, but it's certainly hearsay. The document can't authenticate itself. I believe the site for that proposition is Twiggs versus State. It's 315 Georgia Appeals 191. So this witness can't look at a document and say that it says this phone number is from Justin Cobb's Instagram or social media posting, this is who it belongs to. So that was my objection. I believe the objection was well-founded. I believe the state purposely put that up there after misrepresenting as to whether or not it contained any hearsay in it. And based on that, I would move for a mistrial.
May I respond?
You may.
Judge,
Can somebody put the document up? Everyone see?
yes.
Would you put it up?
First, the state objects to a mistrial. Second, Your Honor, what Mr. Adams indicated that he did not want on here were the comments with where's the phone number? There it is.
Yeah,
okay.
The comments generally being all of the writing on the right side of the picture.
Your Honor.
And so I said to you, is any of it hearsay? Is any of it being offered for the truth? And you said, no.
Your Honor, what I was asking the witness to do is to tell what was of significance to that number and what he did in terms of finding out and corroborating information that he obtained, because he obtained phone records. I don't intend that this evidence or this exhibit will prove or show that this is Justin Cobb's phone number.
You're asking him that? And
No,
asking
Your
him
Honor,
to testify to that?
I'm asking him, and I understand the court, I'm asking him
you?
what handle it's next to, and Your Honor, what he did after seeing what he saw on this
That's
social
not what
media
you
page.
asked, though. You represented at the bench that none of this, that being the writing on the right side of the picture, which we're all squinting at because it's tiny on the piece of paper. And so I am relying upon you to actually be honest with the court and opposing counsel so that we can deal appropriately with the evidentiary issue. Was any of it being offered for the truth? And you said no. And then you turned around, and after it was admitted over the overruling of the hearsay objection, based on the representation that nothing was being offered for its truth, you drew the witness's attention to the phone number and tried to have the witness testify to whose phone number it was. If that is not offered for the truth, what is it?
Your Honor, it
What is
explains what steps he next took. It wasn't that he sat there and took this phone number and said, okay, this is Justin Cobb's phone number. He went and sought records based on what he saw on this social media post. So it's not, this post can't prove anything, but I do expect that the witness will testify based on what he saw, regardless, because it's a legitimate.
Why can't you just, at the bench, when you know that the reason you're offering it is for the phone number, and then to ask the witness other questions about what he did based on that phone number and seeing that phone number, say to everybody so that we know what we're dealing with, you know, it's this phone number, and then I'm going to ask him XYZ about the phone number, and then we'll know what we're dealing with.
Because my understanding that what was being objected to was not the phone number, was the comments that was the words, Your Honor. And again, this piece of evidence does not prove anything, as anybody would be able to say. But when he saw this on Justin Cobb's page, or a picture of Justin Cobb next to what he believed to be Justin Cobb's handle, he sought additional information. The entire
the phone number one of the comments?
I'm sorry, what, Your Honor?
I mean, that is included within what you're now calling comments, all of them just being.
And I asked at the bench what comments they were asserting was hearsay, Your Honor. I literally asked that.
I asked at the bench, is any of this being offered for its truth?
And Your Honor, it's being offered to explain DDA Sprinkle's actions that he took next. Your Honor, these records have been collected as part of what he did in this investigation. He was asked on cross-examination, did he take particular steps to corroborate what was given to him in certain interviews? That was the preceding question before I asked him about this particular post. So the state intended and intends to introduce the records that DDA Sprinkle produced or obtained after seeing this post. This post can't suffice to prove that that is Justin Cobb's number. This post only explains why DDA Sprinkle got the number and why it was significant to him in this investigation, where his steps and actions are being questioned.
According to the defense counsel, Keith Adams, the prosecutor was attempting to introduce information improperly. The evidence in question included a document with an attached phone number. The prosecutor attempted to elicit testimony from a witness regarding the ownership of that phone number, which counsel argued constituted inadmissible hearsay. Mr. Adams relied on specific Georgia case law, citing Twiggs v. State as legal authority. This decision from the Georgia Court of Appeals reinforces established principles of evidence. The core issue was a dispute under the Georgia Evidence Code, which generally excludes hearsay evidence. A hearsay dispute arises when an out-of-court statement, such as information contained within a document or record, is offered in court to prove the truth of the matter asserted, that the number actually belongs to a specific person. As Mr. Adams correctly argued, a witness cannot authenticate or confirm information just by reading it off a document unless they have personal knowledge of the fact. Prosecutor Adrienne Love countered the objection by attempting to utilize one of the exceptions to the hearsay rule. She claimed the phone number was not being offered to prove the truth of the matter asserted, but rather to show the subsequent effect on the listener or the course of the investigation, to explain why the investigator then proceeded to gather specific phone records. This tactic uses the legal principle that statements offered for context or to explain investigative steps are often admissible, provided their probative value is not substantially outweighed by the danger of unfair prejudice.
But Judge, we don't get there. I hear what the state's saying, and it's disingenuous because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained in the portion that I objected to. And the court is accurate. I was there and I asked for everything that was on the right side, all of the verbiage to be, I said that was hearsay. The state said it was not. It clearly is, because to ask him that specific question, I mean, listen, none of us are obtuse. It is what it is. I think that the state was disingenuous about it. The state's being very slippery in regards to their response to the court's questions. I think it's willful, and I think a mistrial is appropriate. And I'm asking.
I can't figure out what it is. If it's disingenuous, if it is that, I don't want to malign the prosecutor standing in front of me right now, so I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful, but honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that. But this case is being made much more difficult for everybody because of the haphazard way in which it is being presented. I'm going to take a recess for a few minutes. I'll have a ruling when I get back.
Judge Paige Whitaker ultimately sided with the defense, determining that the intended testimony was indeed an attempt to bypass the rules of evidence and authentication. The judge found the evidence inadmissible in that specific context, ruling that the prosecution could not introduce the substance of the document through witness testimony without a proper foundation or an applicable hearsay exception. On October 31, 2024, Mr. Williams admitted guilt to a single gang-related count, 3 separate narcotics offenses, and 2 charges involving firearms. He also submitted a no-contest plea for an additional gang allegation and a racketeering conspiracy count. The court imposed a 40-year sentence, the majority of which was suspended. His original 5-year incarceration was reduced to time already served, after which he was ordered to complete 15 years of probation. According to the conditions set by the court, any breach of his probation terms could result in him serving as much as 20 years in prison. Our next case occurred on October 13, 2025. Ex-San Antonio Police Department, Eliezer Alejandro and Alfred Flores were indicted in Bexar County, San Antonio, on charges of murder of Melissa Perez in June 23, 2023. Nathaniel Villalobos also was charged with Mr. Alejandro and Flores, but for aggravated assault with a deadly weapon. On June 23, Melissa Perez's neighbor called to report that Miss Perez was cutting the wires of an external fire alarm system at the apartment complex. Officers asked Perez to walk to their patrol car, and she ran into her apartment and locked the door. Police tried to make Miss Perez come out, but she refused and used a hammer to prevent the police from entering the residence. When Miss Perez got too close to the door, police officers opened fire, and Miss Perez passed away. The prosecution side claims that the officers had no jurisdiction to go on and arrested Miss Perez in her residence, which, without a warrant, can be considered the offense of burglary of a habitation under Texas law. This argument is supported by the Fourth Amendment and Texas Code of Criminal Procedure, Article 14.05, which require a warrant or proven exigent circumstances for police to enter a private residence. Also, she was having a mental health crisis, which was reported by the Miss Perez family. She had schizophrenia. The argument of the defense side: Ms. Perez already had caused a Class A misdemeanor by cutting the fire alarm system, assault and battery by throwing the glass candlestick at an officer, and felony assault by brandishing a hammer. This makes it more plausible to believe that she could throw the hammer on the police officers. The defense also argued their actions were justified under Texas Penal Code Chapter 9, which permits officers to use deadly force when they reasonably believe it is necessary to protect themselves or others from imminent serious bodily injury or death. The case was heard in Bezar County in the courtroom of Judge Ron Rangel. On November 5th, the state called a former CIA and FBI agent, Mr. Chuck Joyner, who is currently a reserve police officer in Texas, to talk about his experience, which can be considered a death or life situation.
And your first employment was where?
My first employment after graduate school would be with the CIA.
And you were there how long?
From 1983 to 1987.
In 1987, where'd you go?
At that point, I became a special agent with the FBI, first serving at the academy, and after the academy, I was assigned to Los Angeles.
I think everybody here will stipulate as far as like background stuff and as far as his experience, that's not really what we're questioning. We're questioning how he applied it to the facts of this case.
I do have one thought on that matter that I haven't shared yet.
Oh, okay, sorry.
It only came to me just now, if I may briefly.
Please.
We were not made aware that Mr. Joyner had any experience as a patrol officer or a peace officer in the state. It wasn't disclosed to the CD. Given that we're litigating a case involving peace officers in Texas and how they acted in this particular case, that would have been invaluable information to have for us to investigate and interrogate his qualifications as an expert in this particular area. It would have allowed us to get records from Spring Valley Village as to his employment, what his actual experience is, whether he's had any disciplinary issues there. We've been kind of deprived and caught by surprise now with this witness. There's really critical information that wasn't disclosed to us. We got an outdated, incomplete CV, and so this feels a little bit like ambush. So we've come into this trial expecting I'll give it to him, experienced in federal law enforcement, but we had no notice that he had any experience in state law enforcement, which, as Mr. Lunan and Mr. Harrison pointed out, is the focus of this case. It's state law enforcement and their standards.
And, Your Honor, that's particularly important in this case after the people who were sponsoring him told the court that he was wrong and that they were not going to be calling him as a witness.
May I ask a few questions about? Sure. Mr. Joyner, is the CV that may have your state law enforcement experience, is it available on the internet?
I don't believe so. I believe on my website it has one of the older CVs and not the current CV. I can check right now if you'd like.
Please. And, Your Honor, while Mr. Joyner is looking up for the status of his current CV, I would also note what has been disclosed to defense. Page 6 of that enclosure, he's listed he's currently a licensed master peace officer in Texas, that he has been a frequent contributor to the Texas Commission on Law Enforcement, TCLO, that he is a member of the Texas Police Association, and in his previous testimony has testified in state courts on use of force against 4 officers charged and against officers so charged in several states in this district, this county, Travis County, Harris County. So there is a basis to determine he's well versed in the application of state law.
And to be clear, Your Honor, my concern is less a matter of qualification, it's a matter of fairness and adequate disclosure of information that we're entitled to under 3914. The very fact that he's a peace officer who ostensibly has TCOL training goes to the very heart of this case. That's information that's in the sole possession of the state. We can't just go get it. It should have been turned over to us as part of the basis for this expert's opinion, and we've received no notice in that regard.
You guys able to provide that to them?
It's information that we didn't have, Your Honor. Yes, we had commissioned him for a report. I don't have it. The CV that I have is posted as what was provided to the defense.
I mean, he's testified about law enforcement matters. He obviously worked as a law enforcement officer, but he hasn't provided that information to you?
The fact that he had state law enforcement officer did not come in the initial product, the initial CV. I did not make a subsequent inquiry from him of that. I don't believe it's any intent to deceive anyone. Simply an outdated CV came forward with the product.
So Your Honor, let me throw this in here. We received an expert report, and this goes to the failure to properly disclose information. We're hearing today that he looked at certain videos for the first time. In the first expert report, he said he looked at Salinas, Alejandro, Villalobos, and Flores body-worn camera videos, and he referenced that in the table of contents and in his report. Then, after we had the kerfuffle about they're not going to rely upon him anymore, Mr. Harris sent us an email about a subsequent conversation with this witness, and it was a disclosure under 3914, and this we asked for an addendum to the initial report. I asked for that by email because of the 3914 disclosure, and this witness wrote a report, and he said that he looked at additional videos of Officer Rojas and Officer Ramos. So what we have here is that this witness is now telling this court under oath that he looked at an additional video that's not disclosed in his expert reports. So there's been a failure to disclose information, and we asked what notes existed for Travis Thompson, and he said he had none. And if we take him at his word that he did in fact look at Travis Thompson's video, he failed to disclose that, and the state failed to disclose that in the addendum that we had asked for in the middle of this trial. So, you know, we asked for witness disclosures and expert reports and expert information prior to the beginning of this trial, and we're giving information in the middle of trial while it's ongoing that they failed to give us at the beginning, which we were entitled to under 3914, under the due process and under the Michael Morton Act. So to permit this witness testifying now would be a manifest injustice, and we ask that he be stricken.
According to the defense, the prosecution is failing to disclose information. In the Texas Code of Criminal Procedure Article 39.14, if the state finds new information at any point, before, during, or after the trial, that they are supposed to share with the defendant, they must tell the defendant or the court right away. This rule ensures both sides have access to the same evidence, upholding the defendant's due process rights. The defense argument is related to the information that Mr. Joyner should not be able to depose due to the state failure to disclose the information that Mr. Joyner is a law enforcement of the state, which didn't let the defense prepare any argument to cross-examine the witness. The defense leveraged this procedural failure to challenge the admissibility of Joyner's testimony based on Texas Rule of Evidence 702. This rule states that a witness must be qualified as an expert by knowledge, skill, experience, training, or education before they can provide opinion testimony. The defense argued that by not disclosing Joyner's status as a current police officer in a timely manner, the prosecution prevented them from adequately investigating his qualifications or potential bias, thereby unfairly hindering their ability to prepare for cross-examination. This lack of disclosure, they contended, violated discovery rules and the standards for admitting expert testimony.
First of all, we went on through this in some of the discovery hearings you might remember before trial. The state has no obligation to turn over things that are not written. Okay, there has to be documents, and there are no documents that he's given us that says I watched some other video or Travis Thompson's video, and he doesn't have an obligation to write down that he watched a video. So that's not discoverable under Michael Morton. It includes documents unless it's exculpatory, and it's not. It's not exculpatory. Unless it's mitigating, it's not mitigating. So this kind of demands that the defense repeatedly make that the state knew something and didn't turn it over isn't required under under our discovery rules and our statutory rules with that.
It's Brady, right? I mean, potential Brady, right?
Well, what they've been given, with the report that they've been given, Your Honor, it says, I am currently a licensed master peace officer in Texas. They know that. They have the ability to send out a subpoena and investigate that and get those records themselves. We don't have his birth certificate. I mean, I don't know if he was born in Texas. We don't have his school records. If he went to attend school, and just because it went to a government, because he's affiliated with a government,
we're talking about potential
obligation
Brady,
on the state.
right? We're not talking about birth certificates or school. We're talking about potential Brady, anything potentially that could have any sort of Brady material, right? You would be,
where he was employed?
Yes, you would be obligated to get that, wouldn't you?
If we had it.
If it exists.
Not if it exists, if we have it. If we have it. It doesn't say if it exists. It says if the state is in possession of those items.
I disagree with you. I think it is required. It is required to get that information to see if there's Brady for the defense to look at.
Okay, if we have reason to believe there's a report or somewhere that provides that information, then we have an obligation to get it. If we don't have any reason to believe that there's Brady material, we can't be obligated to possess it and turn it over.
And Judge, I think
it's just not the law.
I think, with all due respect, I think Mr. Lennon is thinking of the old way of doing things. The responsibility is on them to look. So I think that the court is on the right track. It's their responsibility to look. He got close to saying it's their responsibility to do it, and it's not ours. We've all done that job. Mr. Lennon's been doing it for 37 years. The rules have changed, and the current status, the court is in the right arena for sure. You know that, Judge. Is that the responsibility is on them to check, not if they think. If they think, because what they think is different than what we think, or we would be having this trial. Because I think they're wrong, and they think we're wrong, and so we're having a trial. So with all due respect, it's irrelevant what he thinks. It's what the law requires, and it requires for him to look to make sure, and then to turn it over and disclose it, because it could be potential Brady. We're not saying it is or isn't right now, Judge, but that's not the standard.
And Your Honor, this particular case and instance even begs for more disclosure, because frankly, I have never seen in the entirety of my career the state, and they weren't even going to tell us until they were pushed, when they go on the record and say, oh, our designated expert, he's wrong. We disagree with him. That is certainly Brady. It goes to impeachment, it goes to Brady, it goes to mitigation. And so because of that, certainly we would be entitled, I want to know what his training hours were via T-close and find out what is, we didn't know. I think 16 hours is usually what reserve officers have to accrue to be a reserve officer. It all goes to his qualifications and...
All right, State, so you're making the argument that Heath does not apply in this particular situation? Is that what you're saying?
No, if there was, Heath says if we got evidence, we got it late. If we got it late and we turned it over late and we should have gotten it sooner, or we had it sooner and didn't turn it over, then the court would be able to exclude that evidence at trial. That's what Heath says. That's all that Heath says. So in that case, it was a 911 call or something of that nature. The state turned over to the defense a day or a weekend before the trial, and the state had the opportunity to get it because it was the PD had it the entire time. They're the PD that filed the case with them. And I don't disagree with Heath. Heath is fine. We have an obligation, what we have, to get it to the defense. It's something that we have. Not something we don't have. Not something that's in another agency, in another county, in another state, whatever these kinds of things. Now, if we have reason to believe, because the witnesses told us, he was disciplined as a police officer in Iowa, okay? Then we'd have an obligation of going to get it and ferret that out. But we are under no obligation to look up and do a background check on every witness we have to see if they've done anything wrong. We do not.
I don't know if it's so much a discretion. It seems mandatory at this point.
Fair enough.
So I'm going to sustain the defense objection. Anything else? All right, thank you, sir.
The prosecution affirms that defense would be right if they have the documents of Mr. Joyner to confirm the defense theses. In the 1963 decision Brady v. Maryland, the Supreme Court set forth a more specific requirement that suppression by the prosecution of evidence favorable to a defendant who has requested it violates due process. This is the foundation of the prosecution's ongoing duty to disclose. The prosecutor must disclose evidence or information that would prove the innocence of the defendant or would enable the defense to more effectively impeach the credibility of government witnesses. This is mandated by Texas Code of Criminal Procedure Article 39.14b, which specifically addresses the discovery of expert testimony. Failing to do so could deprive the defense of the opportunity to challenge or rebut the expert testimony, raising issues under the Sixth Amendment of the U.S. Constitution. Judge Rangel sustains the defense objection to not let the witness testify. This ruling likely hinged on the concept of trial by ambush, which courts generally prohibit. On November 10th, the jury returned not guilty verdicts for Eleazar Alejandro, Alfred Flores, and Nathan Villalobos on Monday afternoon. In both cases, we saw the importance of disclosing information by the prosecution side to the defense. The prosecution must be fair and transparent with the defense to have a fair trial inside the legal system. The defense needs to be aware of what is constitutional and what is not in each circumstance. This way, the judge can rule a fair trial based on the legal evidence presented and a fair rule for both sides of the trial. Let us know in the comments if there is any legal procedure that you would like to see. And subscribe for more videos.